Thank All right, Molly, so I guess that means you can start streaming. All righty. Good afternoon. Good morning, everyone. I'd like to first of all thank you all for attending the NICS task force, the April 20th. Before we get started, I would like to do a few housekeeping things. First, I would like to ask that if you're not speaking, that you mute your mics until you're wanting to ask a question or speak. Secondly, I would like to ask that if you do have a question or would like to speak, that you raise your hand. Your hand will be in the little bottom right middle corner, and then we will call up on you to ask your question since this is an open meeting. Also, I'm gonna say this now before we get to the call of the public, so if anyone is watching the stream, they know how to be able to interact with us via the live stream that will be streamed on YouTube. Also, I would like to remind everyone that this meeting is being recorded. So those wishing to address the NICS task force will need to contact our CJ Systems Improvement Department by sending an email to cjadmin@azcjc.gov. Please provide the phone number where you can be reached. Staff will call you during the call of the public for your comment. Due to COVID, no in-person presentations will be made. Action taken as a result of the public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later time. So basically, if you want to interact or you want to ask a question during the call of the meeting, you will email us at cjadmin@azcjc.gov. So with that, I will now turn it over to Mr. Tony Colson for the check-in and administrative agenda.
Well, good morning, everyone. Mark kind of betrayed himself and me in terms of we're not in the morning anymore. Mark still is, but I'm not. The agenda today, we're going to focus completely on a panel interview on Proposition 207. We're going to give you some updates first. Molly and Andy will talk to you a little bit about what's going on at the ACJC and with legislation. And then we're going to roll right into a panel discussion on the new Proposition 207 and what the implications are in terms of expungement and how that relates to the NICS task force and firearms, criminal history records, and how we're going to approach that. So we're going to do that. And then in the end, we will focus on the next meeting. Mark and the staff and have talked about maybe changing up our NICS task force in the future here, kind of going back to the beginning and starting afresh with new objectives, new goals. There's a lot of projects that we have had on the shelf that we may need to revisit again or prioritize, but we want to take a new, fresh look at the NICS task force and the recommendations moving forward. In this, we'll be almost 10 years old soon, and a lot has been accomplished, but we've left a lot on the playing field that we need to reassess again. So we're going to be thinking about a little bit different format, a little bit different direction in the upcoming meetings that we have. So with that, again, as Mark said, keep yourself muted. If you're not speaking, raise your hand if you want to ask a question. We will be monitoring in the chat section. So we will be, if you want to throw something up in the chat, something like that, we will certainly be looking in those areas also. But today is going to be on a panel on the expungement in Proposition 207 and what that means to criminal history records and firearms prohibitions. So, Mark, go ahead.
All right. So thank you, Tony. So the first thing I'd like to do is introduce our Executive Director, Andy Lefevre. Mr. Lefevre, you have anything you'd like to say to the group starting out this morning?
Sure. Thank you, Mark and Tony. And really just a quick word of thanks to the group, to the NICS task force members that have met, and those that have been involved from the beginning, and those of you that are newer and have been joining these meetings and having these conversations. I know it's been difficult when we meet in person, getting everybody together, but I would love to say I see everybody's faces, but I don't see everybody's faces. I see a lot of little dots with letters in them. But I just want you to know that the work that you guys have done and continue to do when you meet and you talk through these issues, how important that is to ACJC and the work that we then try and take those ideas and do something with them. We try and look at policy solutions at the legislature or work through Mark's program with federal grant dollars to try and fix things. Most of what we've done in these areas has percolated up through the kinds of conversations that you have at your level here, identifying problems and trying to figure out how we fix them. So I just want to say thank you on behalf of our commission members to the work that you all have done, to your agencies for allowing you to participate in this important work, and hopefully we'll continue to participate in it. I'm excited to listen to the panelists today, and part of COVID and learning and growing is how do we get this information out further and wider, which is why we're live streaming it out. We did promote this, so I know there'll be even more folks listening into this than even normal. But this is the kind of information I'm hoping that we at ACJC can do more of going forward, which is, where are those topics that we really need to learn more about? How can we hear from the experts about them and inform those conversations at your level, and then again, up through the commission process and ultimately into some solution for that. So again, just a quick note of thanks before I know Molly's going to go over some updates on all the great work that you've done, and I know that you'll continue to do. So thank you for your time this morning and your future time that you're willing to give to help benefit the citizens of Arizona. So thank you, Mark, and I'll turn it back over.
Thank you, Director. So for my part, I just want to make sure everyone understands for this segment of the Prop 207, we're only looking at a small segment of this. So as we're going through the panelists and you have questions, please try to make sure that they're surrounding the expungements or the firearms or something pertaining to that. Because I know that constitutional amendment was a massive amendment, but we're only focusing on a small segment of that. So I'm quite sure there's other questions, but the panelists really are here just to answer the questions surrounding the expungement, the sentencings, and all the prohibitions that were put in place. So please keep that in mind if you're formulating questions, that we're only focusing on this small segment of Prop 207. And with that, I will turn it over to our Public Information Officer, Molly Edwards, for a legislative update or brief update.
Thank you, Mark, and it will be brief. Good morning. We are in our 100th day of the legislative session, and we are waiting for budget hearings to begin. And our team has been tracking approximately 15 gun-related and criminal history-related bills over this session. So in respect of our time, because I know that we are limited, I'll just touch on bills that we've seen movement and or ones that the governor has signed. So real quick, House Bill 2166 was ACJC's data collection bill. This bill was established to authorize ACJC to conduct a comprehensive data survey, that will contain criminal justice records. I mean, it's basically our criminal justice record systems housed at local and state criminal justice agencies across the state, and report outlining, what it's going to cost, what systems currently exist, because ultimately, at the end of the day, we really want to have a comprehensive data visualization center But we have to do this first step, which is the audit of all criminal justice agency systems in the state. Those items that are readily reportable and already exist within your systems. That was signed into law by the governor, and so we're happy and we'll be moving that forward. And we're in the process of getting the survey instrument ready for distribution and hope to be sending that out in the coming week. House Bill 2764, short term is basically, or short title is our CCW bill. It was not introduced because we had actually reached out to a number of legislators, Republican legislators, who were not interested in sponsoring it. They were open to having a bill, a folder open, but they were not interested in sponsoring that. With that being said, Representative Freeze has been taking up the fight. He took it up last year and didn't have any movement on it, and again this year. But with House Bill 2764, it did see a little bit more movement. So Dr. Freeze has met with DPS and other stakeholders to see if we could start discussions on how to develop a system that would be palatable for gun rights groups, to allow for a system. They've been concerned about what FFLs can see. And so they're trying to maybe develop a system that limits what FFLs can see when they're approving someone to, or approving isn't the right term, but the ability for them to sell them a firearm. Even though that bill isn't moving, we really expect that in the coming year, next year, it will be reintroduced again. House Bill 2158 is our protective orders bill. That's our AZ point bill. We've worked with AOC on getting clarifying language that would move the holder of the record back from the sheriffs to the AOC. This bill passed both chambers and went back to the House. I think it may even be today or yesterday was for after clarifying amendment was added, and it is now ready for the governor to sign. So that's a good bill. That was one of those bills that was needed in order to close a loophole. House Bill 2168, use of force data collection bill. This is important for this group just because, again, it's another data collection, and it requires law enforcement to collect and report use of force incidents involving law enforcement officers to ACJC. This is going to hopefully happen after we have completed our audit. So it's supposed to go to the House for final read today, and so we'll know if it passes to go on to the governor for signature. Just after that, I'm not going to go through the other bills, but this session, Dr. Freeze, Representative Longden, Senator Quesada, all Democrats, have led the charge on a number of firearms and CCW and kind of criminal history record bills. To date, none of those bills have had any movement nor hearings, but again, we are very confident that those will again be reintroduced in the next session. So that concludes my legislative report. If Mark or anyone has any questions.
Hey, Mark, could I just jump in? I just want to make sure I heard Molly correctly and make sure it's clarified for the group about the orders of protection bill. The original language that we had introduced did move everything back over to the sheriff, but it was, and Molly, I apologize if you said this and I didn't hear, the core AOC determined that it was able to do what needed to be done in order to move the process through correctly. So the ultimate language that was adopted and will be adopted by the House is just some clarifying language indicating that it is the Arizona Administrative Office of the courts that will do it, not the sheriff's offices. So again, if you said that and I didn't hear it correctly, that's my fault, but I just wanted to make that clear so that we didn't have anybody heading back to their offices raising the pitchforks because something got said different than what they understood.
Oh, and I apologize. You said it more eloquently. I was on speed reading, so I was saying it as quickly and as shortly as possible. But yes, what you said is correct, Director.
All righty. I don't see any hands being raised at the moment. I'll give staff a chance to scan also. All righty. Seeing none on the update. Thank you, Molly. Appreciate it. So with that, I will turn it back over to Mr. Colson.
Well, thank you. As we get into this, I just remind the task force that, and Pat McGrath, who was a proponent of making sure that medical marijuana cards were exempt from reporting to the NICS piece. I know Pat will get a chuckle out of that. But I want to introduce the panel so that we can have this discussion on Proposition 207 and what it means to us. Joining us today, Michael Lee and Brian Larson from the Alcohol, Tobacco, and Firearms in Phoenix. They've attended our task force meetings, have been participants in our meetings, so we welcome them back, but they'll be helping us out on the panel, and they'll be having to leave early, so we'll make sure that we get them in because it's very important of how a state action impacts the federal perspective. We have Amber Slawinski. Amber's here, right? From DPS. And Jared Keenan, an attorney who's going to help us from the Prop 207 side, give an explanation and participate with our piece. And from the AOC, Jennifer Green and Jerry Landau are going to start us off, I hope, with some background and some explanation on what the intent is from the AOC perspective of the law. So thank you for joining us. But if you could give us some background first and the law to get us started, that would be great. Jennifer and Jerry?
Yeah. This is Jennifer Green. Can you hear me?
Yes, ma'am.
Okay. Jerry is going to join us at 9:30. Jerry was tasked with leading an internal judicial branch work group to figure out the ins and outs of implementing Prop 207. That began a couple of months before the proposition actually passed. So we've been looking at this for several months. I was also assigned to lead a group of stakeholders on the expungement statute. So I'm pretty familiar with what it provides and with respect to criminal history. And let me just look at the statute and tell you what it says. This is the new 36-2862. It says if the court grants a petition for expungement, the court has to seal all records relating to the expunged arrest, charge, adjudication, conviction, or sentence, and allow them to be accessed only by the individual whose record was expunged or the individual's attorney. Similarly, the Department of Public Safety shall seal and separate the expunged record from its records and inform all appropriate state and federal law enforcement agencies of the expungement. Then the arresting and prosecuting agencies shall clearly identify in each agency's files and electronic records that the petitioner's arrest, charge, conviction, adjudication, and sentence are expunged, and shall not make any records of the expunged arrest, charge, conviction, adjudication, or sentence available as a public record to any person except to the individual whose record was expunged or that individual's attorney. The arresting and prosecuting agencies will get a copy of the court's order from the court. Similarly, DPS will get a copy of the order. And that's what we've envisioned. We've developed a petition form for individuals to use to request expungement. There are certain data elements on that form that are mandatory and some that are optional. We tried to keep the list to a bare minimum because we expect some of these petitions will involve old cases. We tried to get a handle on how many cases might be the subject of a petition. It's just really hard to know. So far, I have seen basically zero public relations on this. I don't know if the public is at all informed about the option, but the other thing about the statute is it's not triggered until July 12th. So we've got a few months yet to get ready. We have a rule proposal pending. It's the rule number, if you want to look it up on the court's rule website, is R21-0023. The comment period for the rule just closed yesterday. We have to file a reply by May 3rd, and we are planning to revise the proposed rule. It would be Rule 36 of the Rules of Criminal Procedure. It's based on the set-aside process, if you're familiar with that. Amber Slewinski was on the work group. We think we've identified the information the court needs to report to DPS so it can do its job. And so that's kind of where we are. Most recently, Jerry has learned that a number of county attorneys in Arizona are planning on filing on behalf of individuals for expungement. And so we are going to add some provisions to the rule that account for that process. Here's Jerry.
Hey, good morning, everyone.
Jerry, I just went over the provisions of the statute and the fact that we have a rule proposal pending and that we're going to revise it to account for prosecuting agencies that want to file expungement petitions in bulk, if you will, for people. We understand Maricopa County is planning on doing that. I'm not sure who else. And I told him that Amber was part of the work group and was helping us with identifying what information she needs to be able to seal and segregate DPS records.
Yeah, Pima County is looking at it as well. County not at this point. So it's gonna vary, and as things get into it a little bit more, prosecutors may coalesce around a program, or they may decide to do it independently. So yeah, we'll just have to wait and see. I don't know if you commented on. Hey Tony, good to see you again.
Yes.
See your face. Hey, good to see you. The marijuana implementation statute was signed by the governor last week and is now in effect. And we also, because it had an emergency clause on it, and we also had, I don't know if Jennifer mentioned, we filed another rule to amend the rules of civil traffic and voting procedure to include civil marijuana in those rules. And that probably would not affect much this group because there's no firearm result involved. And but the expungement and the no, I'm jumping ahead, just stop me. The expungement is, and it's really somewhat of a misnomer. We all call it expungement because that's what the statute says, but it's more vacating the conviction. Yeah, it's vacating the conviction and all the ramifications of the conviction, including the right to possess a firearm. So if the person's right to possess a firearm was suspended or revoked because of the conviction for possession of marijuana, being a felony, then the person will, at least for this case, will get it back.
I should probably mention also that the statute allows people to seek expungement if their conviction was for possessing 2.5 ounces or less of marijuana, processing not more than 6 marijuana plants, or possessing paraphernalia relating to marijuana. So it's the low-level misdemeanor cases primarily that are impacted by this new statute.
And I'm sure Jerry would have a little bit more. One of the provisions also is 12 and a half grams of concentrate,
Right.
which
Yes.
could be oil, edibles. I would say edibles, but that which is synthesized down into a more of a liquid form, or vaping for vaping purposes. So it also includes that.
And it also includes, which is an issue that came up in court on Friday when I was filling in for one of the criminal court judges, is that it also includes transporting 2.5 ounces of marijuana or less. So it's pretty broad. And so we all have to keep that in mind.
So, you know, and we're getting the bottom part of the hour here, and we'll get ATF's input in because they're going to have to leave a little bit earlier. But let me ask this question. The timing of the petition, is there a limitation on the timing of the petition?
No, I think, and by the way, I'd mentioned that just as background, our administrative director, Dave Byers, formed a task force to implement this. I chaired the task force, but the expungement working group was chaired by Jennifer, so she gets a lot of credit for putting this all together. There is no time limit. Unlike DUI and domestic violence, there is no look back period of 72 months. For instance, you can go back to the time Governor Hunt was running around the Capitol, and if you were convicted for possession of marijuana, you can file a petition, and there's no timing on when you can file. Now, once you do file, there are time frames that kick in, but as far as filing, no.
Okay. And my question goes to, you haven't filed a petition. You are arrested for a new crime, and pending adjudication for that new crime, you file a petition to try to get rid of a prior or an enhancement to a charge. Is that still on the table and viable, or is that restricted?
Yes. There are no restrictions. I'll take it a step further. If a person is in prison and sentenced for, say, burglary with a prior, and that prior is possession of marijuana or transportation of marijuana, and the person can prove that it falls within the initiative, then a petition for post-conviction relief may lie. That's an area our task force and working group chose not to tackle because that's a judicial and appellate decision. But if you were convicted of possession of marijuana and you get picked up for something and you say, boy, I better get rid of this possession of marijuana charge, you can file a petition for expungement. And if I say anything incorrectly, Jennifer, let me know. You could file a petition for expungement.
Wow. Okay. So at this point, and I know it's early and we haven't gotten a lot of in discussion, especially with DPS and notifications and record changes and what exactly a criminal history will look like with this vacated conviction. I'd like to bring in, because I'm wary of their time, and I want to make sure that if there's any questions, that they have time to do that. I'd like to bring in Michael Lee from the ATF. Michael, if you could unmute yourself. And I want to now ask you, how is the ATF, the federal government, and NICS going to handle, what's the federal perspective here?
So the best I can tell you is, first, from my experience. So basically when it comes back is that obviously, with the NICS Improvement Committee, that it's the FBI NICS. So how NICS is going to look at these issues, I actually can't answer for them. The best I can tell you is how ATF has looked at some of these issues in the past, and in particular how we've looked at it enforcement-wise, and that may be helpful for how FBI is going to address these issues in the future. I just don't know. So, obviously we are really looking at two things. We're either looking at whether a person has been convicted of a crime punishable by a term exceeding 1 year, or we're looking, and that's under 922G1, or we're looking at 922G3, a person who's an unlawful user or addicted to any controlled substance. And probably one of the better indicators. The first is that when we look at crimes punishable by terms of imprisonment exceeding 1 year, Congress stepped in on that a few years back and said that we're going to look at those convictions in terms as to in the way that the jurisdiction looks at those. But again, those are just for felonies. The only misdemeanors that ever arise in terms, there's no misdemeanors that arise in terms of federal prohibitions unless it's domestic violence. So really, we're only looking at the crimes punishable by a term in prison 1 year, which generally are felonies, obviously, and then unlawful user or addicted to controlled substance. On the form 4473, that's the form, obviously, that a person fills out if they're going to make a retail purchase of a firearm from a federally licensed firearms dealer. They have the following question. This is what's phrased to a person who's about to buy a firearm. Are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance? Warning, the use or possession of marijuana remains unlawful under federal law, regardless of whether it's been legalized or decriminalized for medical or recreational purposes in the state where you reside. So there's a warning that's placed on there that essentially says, while there has been some changes, obviously, in state law, some significant ones, obviously, along these lines, federal law hasn't really changed along those lines. As for guidance as to how this will be looked at federally, again, FBI NICS has to answer them for themselves. But my agency put out, Congress didn't define what's an unlawful user or addicted to controlled substance. But my agency has the ability to put forth regulations. And they attempted to take a stab at that, as they say, under the Code of Federal Regulations. And under 27 CFR 478.11, they put together a paragraph of some ideas or concerns as to what they think, or hope that how they will apply what is a person who's an unlawful user or addicted to a controlled substance. In looking at that CFR and also looking at a Ninth Circuit case that came out of 2001, the themes that come out of that CFR, as well as the 2001 case, it's the Purdy case, 264 F3rd 809. I'm sure people are writing that down quickly. It's that in some, the CFR basically focuses on whether a person is actively using or has an addiction to a controlled substance. The thing that I think is most relevant for, let me take one step back. Purdy also talked about a person who took drugs regularly over an extended period of time, contemporaneous with their purchase or possession of a firearm. The thing that I think that affects the committee the most and the way things are going to be looked at is one of the examples that's used in the CFR in terms of whether a person is actively engaged in or is addicted to, was the examples they gave that a person has been convicted or possession of a controlled substance within the past year, or there's been multiple arrests for such offenses within the past 5 years. So those types of things are examples of how it may demonstrate that a person is an unlawful user or is addicted to a controlled substance. Clearly, if the purges occur in expungements, I guess is the better way to put it, or even, I guess that's the first time I've seen our state use it. Usually they use the term set aside. But regardless, if the expungement occurs in along those lines, I can't exactly tell you how federal courts are going to look at that. I know the provisions that indicate that the DPS is to inform all appropriate state and federal law enforcement agencies of the expungement. And there further, I see in the statute, it talks about that can't be used by a prosecutorial agency or court. But again, those types of things are governed along state law lines. And so how a federal court is going to view this in terms of if an expungement occurs, Again, that doesn't necessarily mean that that person has gotten past that rubric of whether they're addicted to or unlawful user according to federal law purposes. So I'm sure you've got questions to come out this. Honestly, I can only tell you what the federal viewpoint is based on Ninth Circuit law and the CFR. And ultimately how FBI NICS is going to look at it, I can't tell you that for sure, but I can try to give you my best thoughts along these lines.
All right, Tony, we have a question from Patrick Scott.
Yep. Patrick, your question on...
Patrick Scott, Graf, Patrick Scott.
Where's Patrick Scott at? Yeah.
His hand is raised.
Go ahead, Patrick. Unmute yourself and ask your question.
Well, maybe not. All right.
Okay.
Patrick's probably having the same computer fun that I had this morning, just trying to get this set up. So it's all right.
Here's my question, Mike, which is going to involve you and Jerry and Jennifer, and that is you're conducting an investigation. Is an administrative subpoena or court order to unseal those records? Can that be unsealed?
Well, again, this is a law that's been passed at the state level as to whether a federal district court is going to attempt to unseal that through a subpoena. I just don't know. They certainly have the ability to try to do that. And as to whether that will be honored at the state level and how that will proceed, I'm not sure. But as we deal with separate sovereigns, as we deal with separate sovereigns on these issues, things can be a little different from how it is initially interpreted. But until that is broached, I'm not really sure. Again, as you see the language, it can't be by the statute. You can't be using any subsequent prosecution by a prosecuting agency or court for any purpose. But the reality is that is a contingent upon state courts, not on federal courts. So if a federal court then attempts to subpoena these records that have been previously expunged, what will occur with that? Again, I'm not sure how that will play out.
I don't have anything to add. Jerry? Are you muted?
Hold on, he must have got kicked out. I'm putting him back in now. Hold on one moment.
Okay. We've cautioned in the past. The NICS task force has worked with.
Like Jerry's back, Tony.
Okay. We have worked with the task force. The task force has worked with the Department of Health Services in the past to put out to marijuana card holders, kind of an admonition that, there's a difference between federal law and state law, and still you're considered those in Arizona, since we have Border Patrol checkpoints, it creates an issue. If you pass that checkpoint, you have a small amount of marijuana on you and you have a gun. It could create a problem for that person, regardless of what the state law is. But Jerry, the question we had was on a federal court order or a subpoena. If you're on, in terms of unsealing, what impact that will have. And was it discussed by your task force at all?
I can tell you it was not.
Okay.
Well, and Anthony, I can basically add to the idea that, the prosecution for 922G3 for user addict controlled substances is actually fairly rare in my experience. And so while I think obviously it can occur, while there can be subpoenas that may come from federal district court to see for expunged record, for the practical purposes, it just doesn't happen that often. The prosecution itself doesn't. So I'm not exactly sure how often we would see this actually arise. And then, quite frankly, one of the more common examples that we see of a state-federal difference is in dealing with orders of protection Often, in the state, when you have a judge that's reviewing an order of protection, sometimes they will enact the firearms restriction for state purposes, and sometimes they won't. But for most federal purposes of an order of protection, if it meets the federal definitions, regardless of whether the state has enacted the firearms protection or not, it can often bring about the federal prohibition that we see. So sometimes there are some nuances and overlap or a little bit of separation that can occur.
Yeah, I think where this is going to play most, I know that no one's going to be prosecuted for having an ounce of weed in a gun in the state or in the federal system. But where I think it comes into play is when you walk into an FFL and you're attempting to buy a gun. I mean, this is the Dylan Roof loophole issue, was looking back to find that small time arrest for a small time amount of drugs and looking into that report to do a prohibition. So I'm just wondering at the extent of how far, and this will be a question that we'll have for NICS, how far they'll go looking back into a record to sustain a prohibition based on what they see in a criminal history, whether it's vacated or set aside or whatever.
Tony, can you hear me?
Yes.
Okay, and if Jennifer already covered this, or I lost you for a while, so I didn't hear or see anything. But once it's vacated, it's gone. It's like it never happened. And only the defendant or the defendant's attorney can get it. So it's not a situation of, well, we're going to dig back and see if it was set aside or expunged. It's just not there. And
well, here the question goes to if it is seen and if it is known, can the federal government with an administrative or probably court order more likely come in and unseal those records with a federal court order?
I would say no. But that could be if the U.S. attorney wishes to litigate that issue, it will. And then it'll be up to the courts to decide. Jennifer, please weigh in if anything you have to add. But the statute's pretty clear. It's only can be unsealed for the defendant or the defendant's attorney. And so if either administratively or criminal law, U.S. attorney wants to come in and try to get it, that's something the U.S. attorney will file and it'll go through our court system.
Yeah.
Agreed. I mean, that's how the process would work.
So I guess this question is for Amber. Pat McGrath had a question. How would this basically be handled when reporting back to NICS?
Hi, this is Amber. So what DPS is going to do is when we receive the court order stating that the record has been expunged, we are going to go in and remove the record from view. So the FBI will no longer have a record of it. They're not going to see it. If it's an individual charge amongst other charges, so say the person was arrested for DUI in a stolen vehicle with marijuana, only the marijuana portion will go away off the arrest. So that's how it's going to affect NICS, is they're not going to know it ever existed unless the subject marks that they use marijuana on that form that Michael was talking about. So that's the big part that's going to affect them, is they're not going to see it.
So if a person goes out and filled out the form at FFL and they lie about the marijuana component, when they go to check through NICS, even though they lied, you won't be able to tell them that they lied.
Yeah, that's the, and Amber, if you could, how does the record actually, so it just disappears? There's no annotation on it that it's been vacated or expunged?
Hold on, she got kicked out. Hold on one moment.
No, there's a difference between where we normally think is set aside under our statutes, where you set it aside and it's kind of wishy-washy, loosey-goosey, and you can get it, but you can maybe use it for this, but not for that. This is a hard expungement and a vacate. And don't let the word expungement throw you off, because it's really a vacate of the conviction as if it never existed. So, and it may be out there because these things get picked up by private entities, and it may be on LexisNexis or whoever does background checks. But in theory, it's not going to do you any good because you may know about it, but you can't use it for anything. So that's, just don't mix up the set aside as we commonly know it with this hard expungement.
I just have in Melanie, and there's others UPS, is how you act. Once you put something in the system, how you actually make it disappear so that no one can see it.
It's Amber, I'm back. How we actually make it disappear is we're literally removing it from the CCH database where it's viewable. We have a new database that went live on Sunday for CCH that allows us to click a button and it hides it where my staff can't even see it unless they send in a specific type of message to say, find this record. So it's not something that's going to be viewable to anyone once my staff clicks that button.
And I want to make the distinction, it's not viewable, but the record still exists in some type of electronic format somewhere, correct?
Yes, it'll be in the new CCH inactive database. So it's a database that literally only my 20 staff have access to. It will not be on a rap sheet at the state or federal level in any way.
And my question is for federal purposes, NICS purposes, when they look in, say, III is it just a path to CCH?
So yes, but there's two portions here. So if the subject was arrested 6 months ago and Arizona owns the record, which means Arizona has the one and only copy, when I delete it, that means nobody else can see it. If it's a 1965 arrest where Arizona has a copy and the FBI have a copy, I will get it out of my system and I will notify the FBI in our normal notification of a correction or modification of the court order and provide that to them. And then it's upon them to make the decision of whether they're removing it from their permanent record. Okay. If it's an Arizona only record, I can hide it. If it's their record, I can't hide it.
And what would make an Arizona, and I'm asking for clarification purposes. So if I have an understanding that anybody that's arrested for anything, misdemeanor, becomes viewable across the nation as an arrest.
Yes.
Is that a misconception? Are there some records that you don't share with the national database?
No. So what it is up until the early 90s, when a subject was arrested at a police department, they would take 3 copies of fingerprints, one to send to the FBI, one to send to DPS, and one for themselves. If they failed to send the record to us, then FBI would have the only record of that record. Or if they sent it to both of us, but Arizona and FBI's records don't match up for some reason, then our records are not owned by Arizona. That record would be partially owned by the FBI. So the FBI makes independent decisions on whether they're going to continue to maintain and own that record.
Okay.
Excuse me. This is Pat McGrath. The question that I had asked on the chat was, and Amber answered it very well for me. My question was, will a person that has a conviction vacated or expunged, would they have to apply to the court then under 13.925 to have their gun rights restored? And looks like most of these convictions that would be expungible would not be would not be sent to NICS. If they were in NICS, it's probably for another conviction, like of a felony. So my question was answered. Thank you.
Yeah, I would add one thing, Tony, that I think we're going to find the number of these convictions are misdemeanors. Because in counties outside of Maricopa, and Maricopa may be the only one, and maybe Yavapai, I'm not sure, that predominantly files these as felonies. But in many cases, they end up as misdemeanors. Most of them is my understanding. So I think most of these, or a good number of them, what's being expunged is really a misdemeanor.
That's true, but it's also important to note that the FBI, like Michael was saying, the federal level doesn't allow marijuana use of any kind, whether it's a felony or a misdemeanor.
Oh, no, I understand that. I'm just saying that from our standpoint, they may have been misdemeanors.
Yes, that's true. I do have a couple of points that I would like to have addressed if possible.
Hang on, Amber.
Yeah.
I hate to interrupt you, but I want to be mindful of Michael's time here. He's going to have to leave us. If you have a question directly for Michael, that's good. But I wanted to give Michael a chance to kind of close out before he leaves us here.
So I think that what Jerry and Amber just brought up was very critical in the respect of the fact that, the way Congress has set up the review of felonies is that if there has been a restoration of civil rights, expungement, or set aside, then that felony is not considered usable in most situations for a felon in possession prosecution. So that, and in fact, the statute itself literally says you're to look to the jurisdiction as to how you're supposed to look how that particular jurisdiction looks at that proceeding. In other words, if a state does not consider this a felony anymore, neither shall we. There's been aberrations of that in other circuits. The 10th Circuit basically has made a statement that if a set aside does not act like a pardon, that it is not a proper set aside. But the 9th Circuit doesn't have that type of rule at this juncture, and that's what we're concerned with. But in terms of 922G3, again, that's where our misdemeanors come into play. And if a history of that exists that's fairly recent, that tends to demonstrate that, as well as if a person is admits to having this type of behavior that's occurring in their life, then the FFL is going to have a hard time going through with that sale. But again, it's time dependent. It's contemporaneous use, in other words. So as how this will eventually play out, I think that as Amber's indicated, that as it comes off the records, that we'll lose that temporal component in demonstrating that this is occurring, at least for marijuana purposes. But it doesn't mean it can't be used if it comes up through some other source and some other means. Ultimately, whether a district court is going to try to send a subpoena through a federal court to state purposes to try to look at an expunged record. Obviously, I don't know where that's going to go, if that ever occurs, or if that's even on anyone's radar. Clearly, it could happen in the extreme case, but I'm not sure, because of the infrequency of how often an actual prosecution for 922G3 and especially for marijuana is occurring. We just don't see it that often at this juncture. It's a possibility, but we just don't see it that often.
Okay. Very good. Thank you, Michael. I appreciate your time. So
glad to help. Thank you.
Thanks. Amber, go ahead. Sorry about that, but I just wanted to make sure that Michael had a chance before he signed off.
That's okay. So to start, this law still prohibits people from driving while intoxicating and flying planes, driving boats, those types of things. Those are covered under the 28 statutes, which we may or may not see an increase of people being arrested for that. If we do, that is going to be a gun prohibitor, because they do look at the DUIs and ask what type of influence they were under. So a marijuana usage would still prohibit guns. As far as the other part of the law where it states the person cannot smoke in public places, the person cannot consume marijuana in a vehicle, even as a passenger, whether they're not allowed to have more than 6 plants or 2.5 ounces. I don't know if anybody has identified a statute in which the officers are going to cite those under. So that needs to be addressed if it has not already been addressed. There's another section that states if the subject has been charged for 3 times, on the 3rd time the subject has been charged for having more than 6 plants or more than 2.5 ounces, it is a class 1 misdemeanor. It's unclear as to how anyone will know there's 2 prior incidents since it's not stored in my database. So that may need to be looked at. The other portion that is a real big thing for me that I think that we need to ask one of the co-authors of this is there is a phrase in there that clearly states that this is for 21 and older, but then they use the word adjudicate. Adjudicate in the state of Arizona is interpreted as somebody under the age of 18 that went to juvenile court. So the way this is being interpreted is if you are under 18, you get a free pass. If you're over 21 and you use it, you get a free pass. I know that the juvenile courts and probation are dismissing cases against their minors, but I think that's a misinterpretation of this law, which is going to possibly cause more kids to be using marijuana because people are misinterpreting it based on that one from adjudicated.
Okay.
All right.
That-
With that, Tony, we do have Jared Keenan available.
Yes, Jared, welcome on board. Before we get to you, Jared, I have one question for Amber. 133411, possession in a school zone.
Uh-huh.
And Jerry and Jennifer may also have to. So now we have kind of a situation where we have possession that may be under the threshold, but it is in a school zone. Is it looked at differently? Is it not a violation, or is it a violation?
I have no say in that and no real comment other than if we let this 17 and under have marijuana, you're going to have more kids nailed with that because there's going to be more kids with weed at school because they think it's okay. And that's a felony if they're picked up with that at school.
Okay.
Tony, let me mention, the drafting of the initiative, the use of the word adjudication has put juveniles at risk. And there are different interpretations of it. I think at this point, we're taking the interpretation that the initiative does apply to juveniles. And that's why juvenile probation is acting accordingly. But there are people out there who do not believe this initiative applies to juveniles. But that could be a litigable issue. I'm trying to remember the initiative. I don't believe that there's any differentiation for school zone. So it's not an exception that's mentioned anywhere.
So what you're saying, Gary, is if you're an adult in a school zone and you have this or less of that amount, you're okay. The school zone doesn't change the nature of the language.
That's the best we can tell. And, one thing we have to realize that there are provisions of the initiative that are open to interpretation. And as in any other initiative and statute for that reason, it very well could be some litigable issues. I can't talk for the 15 county attorneys, and I can't talk for the 7 Supreme Court justices and 18 or so or 18 or so Court of Appeals judges. So we're just going to have to wait and see. But I don't see anything in the initiative that carves out an exception for school zones.
Okay. This is a great segue in for Jared to, there's a lot of questions about drafting and interpretation. Jared, welcome. Thanks for joining us. If you can unmute yourself and you're up. Yeah, go ahead.
Thank you. Thank you for having me. Sorry, I joined a little late. I didn't have the link. Are there specific questions that folks have that they want me to address if I can?
Well, Amber had a lot of good questions in terms of what certain things mean. We certainly have talked, about, does this apply to juveniles? Before you came on, we had alcohol, tobacco, and firearms in terms of the federal perspective and what that would mean, which is, I came away with, it's still up in the air of how it's going to be, how it will roll out in the courts if someone wants to unseal something or do a denial based on, something that is sitting in a federal database or sitting somewhere. One of my biggest concerns that Jerry brought up is that LexisNexis, all these databases out there that do background investigations capture stuff as it comes. And so most of this stuff is captured in open source information that can be retrieved and used again. So one of the things that I'd like to go back to is Amber had a number of issues with drafting and what certain things mean. And Amber, if you could just come right in again and repeat those for Jared, and let's start a good conversation here.
Sure. Well, I don't think that the first part about what statutes are going to be imposed about public smoking in public or riding in a car and smoking, I think that's for the legislature to deal with, or lawmakers to identify what law the officers need to charge with. My main question for Jared is, the law specifically says that this is for subjects 21 and older, that they may now have marijuana. But at the same point, there is a phrase in there stating the subject has been adjudicated, that they're forgiven for that offense. Adjudicated in the state of Arizona is broadly known as a juvenile charged in juvenile court. This would imply that children under 18 are allowed to smoke marijuana and have it in their possession. Was that the intention of the law?
So I don't believe, what section are you referring to?
Jennifer, I think it's the very first section. Is that correct? That it talks about adjudication?
The expungement statute repeatedly references not just arrest, charge, conviction. It also says adjudication. If you have been adjudicated responsible or guilty for 2.5 ounces or less, you may qualify for expungement. Did you intend that to mean people who are charged and found responsible as delinquents? We call that not a conviction, but an adjudication. Can they qualify for expungement?
I believe that they can, but I don't think that undermines or changes the legalization piece of Prop 207. So I guess what I'm saying is getting an old adjudication expunged under the expungement portion. I would say that yes, the intention was to make both convictions and adjudications expungible, but that doesn't, like I said, I think that's a completely separate question from the way it was Amber posed it, which is does that allow people under the age of 21 to now legally consume marijuana? And I think that's no.
So how does that make any sense at all? If it's no longer a crime, I can see you should qualify for expungement, but for people 18 and under, it's still a crime or an offense. So why do they qualify for expungement?
Well, I believe that if you're under 21, there, at least for the first offense, right, it's a civil infraction, if I remember correctly. I worked on, so just to be clear, the portions of this proposition that I worked on were the sort of broader criminal justice reform pieces, for lack of better term. And so like the expungement, the justice reinvestment portion, and the licensing piece that sets aside 26 specific licenses. These were the areas that I sort of had some input on. And so with that in mind, the purpose, at least from when we were discussing the drafting of the expungement piece, was to help those, to broadly allow for expungement. And like I said, if I remember correctly, again, this isn't the portion I worked on, but if I remember correctly, the way that the reason that makes sense is because for those under 21, at least that first time is a civil infraction.
So my concern with that is that kids are not allowed to buy cigarettes until they're 21. But the way that this is being interpreted, the courts, the juvenile courts and the juvenile probation are releasing kids that are currently in the process of being disciplined through their processes of going under for a new charge of possession of marijuana or for using it while on probation. Those cases are being dismissed because this is being interpreted that kids are now allowed to smoke marijuana. I think that that's going to lead to a lot more problems if we don't clean up the law and make it very clear throughout the wording, not just in the phrase of 21 and older, but throughout the wording that kids still cannot have marijuana.
Now, hey, Tony, Amber brings up a point that is nothing, I'm not sure there's much that we can do because it's in the drafting of the initiative. Yeah, there's a bit of a disconnect because for a person 21 or above, if the person was convicted of I'll call it expungible offense, then the person can go in and obtain expungement and vacate the conviction. But it was a criminal conviction to start with, and now it's off the books. That's pretty simple. For a juvenile, it was a juvenile adjudication to start with, but now you're coming into being expunged, and it's off the books. The initiative didn't take into consideration in the expungement provision that there is still a civil remedy for juveniles for possessing marijuana. It just left it. You can expunge the person, expunge the conviction, vacate the conviction, and there's nothing left. Now, it could have theoretically said you expunge the conviction, expunge the records, vacate the conviction, or turn it into a civil violation. That would have filled in the gap. But it doesn't say that. So there is a gap. Yeah, if you were previously adjudicated for marijuana, that adjudication gets vacated. Now, if you go out and get picked up again, you will get a civil violation. Then it becomes a petty offense, if I remember right, for the second and a class 1 misdemeanor for the third. So yeah, it may send the wrong message, but it's all in the education and the training. But that's not something that we are concerned with, I don't think, in this group. This is what the law says, and we may like it or not like it, and it may need changes, but if it's going to need a change like that, it's going to have to go back to the ballot, et cetera, maybe. So I'm not sure that's for us.
Well,
At least that's my take on it.
It becomes a consideration when, as a predicate offense for a juvenile or with special circumstances, and Amber could probably talk to what those are. If it becomes a felony, juvenile delinquent adjudication, those are going to, starting probably this month or next month, those are going to be transmitted to NICS, and that's going to follow this juvenile for until the rights are restored.
And I think that's correct, because if we leave it up to interpretation and like you said, Tony, if this kid goes to school with marijuana and the prosecutor that prosecutes chooses to prosecute him as a felon for being on school grounds with it, didn't we just set that kid up for failure by making people believe that kids can have marijuana and then that kid being prosecuted for having marijuana, but at an adult level?
Well, I have no doubt that the kids already, you can use just when you can have it expunged at a later date type of thing. So yeah, you're de facto.
It's different if kids' parents are giving it to them because it's not a big deal, it's not a violation, which we know that parents do that. But I don't know if any of you have driven past the marijuana stores. The lines are wrapping around the buildings. It's going to become more prevalent, and I don't want these kids to get caught up because we can't make up our minds how the law should have been written.
Well, it's not so much for us to make up our minds in something like that, I don't think. If you have a person who gets picked up in school with marijuana, a 17-year-old, and the prosecutor decides to file it as a felony, and Jared can talk to this more than I, the defense attorney might move to dismiss because, and then it's going to go up the, and ultimately there'll be a decision. It's not for us to try to make that decision because we're not the judges.
And can I point something out here? The expungement only applies to cases arising out of conduct occurring before the effective date of the expungement section of the initiative, which is July 12th, 2021. So if you're convicted of something after that date, you're not going to be able to expunge it.
Okay, so that's
the new charge is the new charge, and the person will be adjudicated for it or convicted, or there'll be motion practice and court action to deal with it.
Yeah, if I can.
Go ahead, Jason. Go ahead,
Thanks.
Jared.
So I would say the concern that we had with some of this was understanding that the voters would likely only want to pass a legalization initiative that made, with the 21-year-old and above cutoff, right? That we weren't going to be able to, or the voters were likely not going to support something that allowed for marijuana consumption below that age, and certainly not for children. Coupled with the concern that the reason you don't want to allow kids to use marijuana is because it's more harmful to younger people, right? But knowing that if you don't legalize it for younger people, then the problem is you create a situation where the people you're trying to protect from marijuana are the very people now that are able to, the only people now that are able to be criminally charged with possession. So there's some tension there. The goal, I would say, of the way this was drafted was and is to sort of start with a clean slate when marijuana was is legalized, right? And so because the way the language works is the penalties for possession of marijuana for those under 18 increase exponentially as you get more and more offenses, right? And so the purpose was to sort of start with a clean slate so that juveniles would be able to get their prior adjudications expunged, so that those wouldn't be counted as priors in the sense of the increased penalties going forward. Does that make sense? And so the hope was, or the goal, I think, the purpose of drafting it this way was that juveniles would be able to get those old things expunged, but if they were to be caught with marijuana going forward, it would be a civil infraction, petty offense, so on and so on. Did I confuse everyone even more?
No, I think we got the concept of the logic behind it. Yeah, I think what you're saying was that you wanted to clean up the backlog in a sense and say, all right, everybody starts from the same starting point if you're in a race.
Right.
And so therefore, If you mess up or you do something after this date, then there are penalties for that.
Correct.
Yeah, I think we understand that part. So I guess I have a question for Amber. So how will a NICS return look now?
It'll be blank.
Say that again.
It will be blank.
It will be
If the
blank?
only charge, yes, if the only charge they had was for that one marijuana that has been expunged, then the FBI will get no response, or the NICS indices will get no response from Arizona.
Okay. So on the court side, they have to petition the court. And there's some language in there that says something about the prosecutor can file on the court's behalf or on the subject's behalf. So I think Jennifer said there are going to be new petitions strictly for this process.
Well, we're mandating a form for the public to use. How the prosecutor's office files these petitions for people is probably not going to be subject to that mandatory form, but they can file something more like a list that includes the required data elements for each individual. And then the court will have to create individual orders, probably, that will give DPS the information it needs. I'm not sure. We haven't gotten through that.
But isn't that going to make disparate? Isn't that going to be disparate across the state? You'll have Pima County submitting for instance, Pima County is submitting a list on behalf of everyone in Pima County that fits the criteria, but yet in Pinal County, nothing.
Well, Tony, in that regard, there has been some interest from both the prosecution and the defense, I'll call it that, the petitioners and the prosecution, for what I'll call bulk filings. And of course, every case has a case number. Every case has a file, be it electronic or paper. And the filings on that particular case have to be placed in each individual file. So normally you file a motion on a case or a petition, and it goes in that file.
Right.
Both sides have expressed an interest in the quote bulk, and we have to work through that and look to see if we can accommodate both sides. But there is I don't anticipate, and again, I don't anticipate a mandate of bulk filings. It's going to be up to an individual petitioner. My guess is, I don't know, maybe there's a group. Jared's on the phone, so I'll use ACLU. It may not be the appropriate group, but ACLU may decide they'd like to file a bulk petition representing, or the Innocence Project at ASU might want to file a bulk petition. Maricopa County Attorney's Office might want to file a bulk petition. But other counties that may not, so they'll file individual petitions. One way or another, the petitions will get into the court and we'll deal with them.
So let me ask you this. Can someone petition in any county, in any court?
The rules will state you have to petition in the court where the case was resolved.
Yeah.
And DPS needs a court order, so we need it to be specific to who the person is, what the charge, what the case. They can't just say, get rid of their 1982 case, because they could have 7. They need to be specific.
That's why we have certain requirements in the petition. That's why bulk filings may be an issue in some cases. You know, it's like anything else, you got to work through it.
That sounds pretty complicated.
And we're obviously concerned about volume here. We don't know how popular this is going to be. So some of it may have to be resolved on the fly. so to speak, but we do want to make it as efficient a process as possible. I have looked at how other states have handled this. I noted in a few states it was being done by Board of Pardons and Paroles, or there were global pardons issued by the governor's office, I think, in one or two states. But for us, it's going to be a court process.
I have a question. So if a person goes for an expungement and they were prohibited from purchasing a firearm, does that expungement automatically restore their firearm back to them?
If I'm deleting the rest, then nobody would ever know they were denied before because the arrest is gone.
The court order will restore the firearm right if there's not another conviction that would prohibit it. That's the way the statute calls on the court to resolve that issue.
So who's going to do that research that there isn't any other prohibiting charge?
I'm not sure we're going to do any research. It will be up to the subject of the petition to know that.
Well, the petitioner obviously has an interest in getting their charge expunged, but the petitioner may not have an interest in saying anything else. And so, unless you have instructions of petitioner, you have to list every crime that you were convicted of in the past. But
No, I don't think it works that way.
Are we putting all faith in what it's in the petitioner, that there's no other factors that would be otherwise prohibitive of having?
The instructions for the petition will warn them about this, as will the court's order, that their gun rights are restored only to the extent that they may be restorable for the expunged charge, and that there might be other cases that would prohibit them from possessing a firearm. So it's a warning.
Yeah, Tony, you and Amber can maybe answer this in that regard. I kind of equate it to driver license suspension. If a person's gun rights are removed on 3 separate charges, and one of them is vacated, it's still going to be in the system that gun rights are not restored on those other 2 charges. And so they will not be restored. It's like a driver license suspension. If you fail to pay or fail to appear in 3 courts, and then you take care of one of them, you still suspending the other 2 based on the other 2 charges. So yeah, there is a responsibility on the person, and NICS, I assume, will still show the other action.
Correct. We'll only be modifying the charge or case that it specifically relates to. So if it's an incident where it's one charge of marijuana under the 2.5 ounces, then we'll get rid of that. But like I said before, if it's linked to multiple charges on the same one, we'll only get rid of the marijuana charge. One reason I was not in favor of the big bulk, everybody just get their record deleted, is that state of Arizona law does not specifically indicate the quantity in the law. So the law currently says for possession, for use, or for sale, but how many ounces that is. And we all know that a lot of times those are pled down. If they are for sale, they're pled down for use. So it's just too broad to say that I'm going to do a sweeping remove 200,000 charges from my system, which is what I have for marijuana possession.
Yeah, the thing is, though, Amber, once the order comes through, it doesn't make a difference to you what the amount is.
Exactly. I'll have a court order.
Yeah, you'll have a court order. So if the person had a pound, but the prosecutor chose not to fight it, that's not your concern, really, or you don't have to worry about it because you got the court order, so you're safe.
Yeah, I was just saying the reason we didn't want to do the bulk and get rid of 200,000 is there's too much variation and we don't know what they were.
Well, it doesn't make a difference. Even if there's a bulk order, a number of cases, you're going to get an order on each one, and they all are under 2.5 ounces or less.
Correct. I was talking about the bulk deletion, just somebody saying, Amber, just delete everything without a court order or anything, just the.
Oh, no, you can't do that.
Yeah.
Oh, no, you can't do that.
So, but Jerry, so the petition gets placed in, and then the prosecutor has 30 days to decide whether to answer the petition or not. Then there's going to be a finding by the judge on fact and law in terms of the expungement. Is that my?
Yeah, the plan most likely, and it's done now for restoration of civil rights, there'll be a petition for expunge. Say Tony Colson files a petition to expunge. A copy goes to the prosecutor. Prosecutor has time to respond. When the copy goes to the prosecutor, there'll be a notice. If you don't respond within 45 days, we leave room for mailing and all that. Then the court may grant the petition. So if the prosecutor doesn't respond, the court very well may, okay, no response by the prosecutor, and therefore we're going to go ahead and grant the petition, and then the order is issued, goes to DPS, and we're done.
Okay. So, is there a time frame that the judge has to have a hearing in?
The judge never has to have a hearing. The judge can order a hearing if either the prosecutor or the petitioner requests it, or if the judge finds that there's a material issue of fact.
Yeah.
Okay.
But otherwise, the judge could grant the petition without a hearing. I suppose the judge could also deny it without a hearing if the petition is on its face, right? If it's a petitioning
Right.
for an expungement of like a assault charge, right, that doesn't qualify, the judge could just dismiss that.
Yeah, and
Deny it.
there are other rules that say a judge can't keep a motion or a petition pending more than, I think it's 60 days.
60 days, yeah.
Yeah, without a reason. So,
But either way, in the court order or the minute entry, the judge has to make a finding of fact, whether it's petition, whether the prosecutor, whether the judge decides on their own or whether he holds a hearing, he or she holds a hearing, there has to be in that order a finding of fact in law, right?
I think the finding of, someone correct me if I'm wrong, Jared or Jennifer, the finding of fact only applies if it's denied. But
I think-
Well, the way we've drafted the standard statewide order form, it will read, pursuant to the statute, the state has not established by clear and convincing evidence that the subject of the petition is not entitled to expungement of the requested records. That's one option. The other option, pursuant to the statute, the state has established by clear and convincing evidence that the subject of the petition is not entitled to expungement. So it's the state's burden by clear and convincing evidence. If the state does not respond, then the petition will be granted. Or obviously, if the prosecutor files the petition for these individuals, that's going to be granted without any hearing.
Okay.
And there needs to be a finding of fact.
Yeah.
Yeah, I wish I wasn't in there because it'll slow things down somewhat, but there does need to be conclusions of law and findings of fact.
Okay.
And the way the rule reads, if the petition doesn't provide enough information for the court to locate the records to be expunged, it can be dismissed on that basis. Although the order will say that the person can file another petition if they can provide additional information. And the rule also says it can be dismissed if the conviction or arrest was for a charge that's not eligible under the statute for expungement.
Tony, I think we need to open it up to the members to see if they have any questions.
Yeah, Patrick Scott had a question on retention schedules. Patrick, you want to unmute yourself and ask your question?
Yeah, I think a lot of times what we've found is people will come in to have something set aside under the current statutes, and our records retention schedule is only 7 years for DUI and DV and 5 years for all other criminal actions. So what are we going to be doing when people come back with a 20-year-old case to have record expunged?
Well, we did look at this issue. We think under the statute, people are now entitled to expungement. I know for set aside, some courts will refuse to set aside a case if it's so old they don't have it anymore because it's been purged. But we don't think that's allowed by this statute. So if the court has already purged its case file, we're going to assign a new case number to the petition that allows it to be processed. The order will say the court has no records because they've been purged, but then it will pass the order on to DPS because they've still got a record, presumably. And the same with prosecuting agency and arresting agency.
My understanding is, and I don't know any of the details, that the person can seek from DPS and the FBI some information. How that works, I'm not sure.
DPS can't do anything without a court order. They can ask the FBI for a NICS appeal if they're denied their gun.
Okay, thanks, Amber.
Anybody else, any questions?
This is Ellie Fan. It's not really a question. It goes to what Tony was saying. When you're talking about findings of fact, one of the things we talked about in the committees that both Jennifer and Jerry led is that these possession of marijuana cases that we're talking about don't have a quantification. They would just say possess marijuana. So we don't know if it's 2 pounds or 2 ounces. And the possession of drug paraphernalia complaints don't specify what drug. So if we're not going to be making findings of fact that they possessed over or under. It's going to be exactly the way that Jennifer has stated.
Okay.
In essence, once a petition's granted, it's I say presumed, but it's really conclusive that it was for these purposes, it was 2.5 or under, or the drug paraphernalia was for marijuana. The prosecutors will have the initial burden of trying to figure out what is real and what's not, and make a determination as to whether to move forward.
Jared,
Yeah,
if
I could jump in, this might help. It doesn't really answer any specific question, but just as far as background goes, it might help folks. So when we were discussing the there was a couple concerns that came up. So like overall, I would say the goal from the drafter's point of view was to make as many people eligible for expungement as possible, right? To make it as broad as possible. And so we then thought through some of the issues that would come up. And Ellie's point is one of them, right? Is that because what is expungible is something that wasn't tracked in criminal cases for years, right? All that really people cared about was whether it was a usable quantity, not necessarily how much, unless it was like an exorbitant amount, which might actually play into a higher sentence or something, or over the threshold and stuff like that. But for the most part, a lot of these cases, and obviously pleading down and stuff, just as long as there's a usable amount, that was enough for most criminal cases. And so we knew that going into it. And so that's one of the reasons why the drafters made the burden, placed the burden on the prosecutors, because again, to go along with a sort of broader goal of making it as easy as possible for folks to get expungement, and also realizing that the prosecutors may be the ones who would have records indicating whether or not the amount was over 2.5 ounces. And so essentially what the expungement portion is, so how it's basically supposed to work is it very likely will capture cast a larger net and allow expungements for people who actually may have factually possessed more than 2.5 ounces, but that by placing the burden on the prosecutor's office, right, that's only going to be an issue if they're able to prove that. And if they're not, then for the purpose of expungement, it's going to be considered expungible.
Okay. Anybody else have any questions from the task force? I may not be able to see your hand, so if you have a question, just speak up. I don't hear anybody speaking.
So I still see this as, and Jared, you can speak to this. I still see this as kind of a disparate application across Arizona. There are going to be some prosecuting offices that I can predict that are going to contest everything, that they're not going to make it easy for a petitioner. And then there's some counties that are, would look at bulk and let's just clear all these folks out. And, so that means where you're sitting is going to determine if you're going to get your record expunged or not.
Yeah, that's a good point. So we discussed that, and we put in the piece. We thought putting in the piece about petitions being filed by the prosecutor's agency made sense because some might want to do that, and second, they are likely, other than the court, the one sort of agency that would likely have access to data to pool a bunch of people who would qualify for expungement, which is why we added those things. But you're right, there likely will be disparities across the state on how prosecuting agencies that are very much supportive of expungement and helping folks get expungement, and those that are fighting a lot of these petitions. I would say, and this is certainly going to be a not a satisfactory answer, but that's kind of how things work generally, right? Like prior to 207, there were disparities across states about counties that would mostly file simple possession and paraphernalia as straight misdemeanors. And there's other counties that would file them as felonies every single time, right? Whether or not they would allow you to plead down to something like an open 6 or something is a different question. But there are currently, particularly with marijuana, large disparities between counties in how they're charged. And so it's not that we just couldn't think of a way to answer that problem. And so we tried to make it, like I said, as broad as possible to make it as easy as possible for folks to get expungement. And again, in the counties that, let's assume hypothetically that there's a county attorney who is going to fight a lot of these petitions, by placing the burden squarely on them, I think dampens that possibility, right? It makes it much harder for them to challenge lots of petitions. And so it might answer your concern about disparities across the state.
So the caseload's going to go up dramatically, and it's going to take away from other things, which would.
Correct. And then the other thing, I guess, is that's also the reason why there's that $4 million set aside to assist with expungements. I don't know, obviously, at this point, who's going to get that money, but in theory, a nonprofit who is offering legal services would likely be using those resources in counties where they're fighting a lot of, the county attorneys fighting a lot of these petitions, and less so in counties where they're not. So that may also help with the, because the hope is that you won't need an attorney to do this. Although if there's money available and nonprofits willing to supply an attorney, that those attorney resources would be used in places where there's a fight about the petition.
Okay.
All right, Tony, I got a question to Amber. Amber, do you have any idea what type of impact this will have on NICS, or what type of restorations we're looking at as far as people retaining their rights back for their firearms?
I have 200,000 records of marijuana possession in my system, so I have no clue how many people will actually ask for that back.
Okay. Do you have a projection maybe? Or you run some numbers or anything?
No way to know until people start asking.
And
Yeah.
that will be July 12th. Okay.
So Amber, here's my question, but I'm going to put you really on the spot. Court grants a petition, signs the order vacating the conviction, restores all civil rights. Clerk notifies DPS, prosecutor, and law enforcement agencies that the records are sealed. The clerk notification to DPS that the records must be sealed and separated. DPS must notify state and federal agencies. In that, which is section C, it says DPS can charge a fee for doing this. What are you going to be charged for, and what if they can't pay?
Well, right now I'm not planning on charging a fee,
Okay.
but it also says that I can't charge if they're indigent or poor. So even if I did charge a fee, I'd have to figure out a way to know if they're indigent or unless they're in prison and they're marked that way, I wouldn't know.
Okay. So why, what if you did charge a fee? Not that you're going to, but what activities was contemplated in terms of fee charge for these folks?
Well, that was part of the bill, so we weren't part of writing the bill, so that was just them writing it in there for us. But it would be my man hours and the research it takes to do it. So for example, if I get a court order that says delete charge from 1982, blah, 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 and gives specific information, and I have no record of that arrest to begin with or of that person, then that just took maybe 5 minutes, maybe 2 hours, depending on how many AKs the person may have or come up, for my staff to research whether that person has a record. So it states that the subject has a record and the case is dismissed and it all looks good and we can get rid of it. That's 5 minutes. But if the subject submits to have 45 arrests deleted, that could take 40 man hours. It totally depends. So we would have to do it probably not a case by case. It would probably be a flat fee, but we haven't even started talking about that yet because we will be getting reimbursement from the proceeds of the marijuana sales.
Okay. So just like as Mark asked in terms of, what's your volume going to be, you don't really know how much it's going to cost until you have a sample size.
Correct. We were asked in June of last year to tell them how much it would be, and we went with worst case scenario. And if people were petitioning the courts and the courts were refusing to deal with it because they had no copy, like Patrick said, and if then we had to go to OA hearings, which it would entail us having our judge and OA, or our attorney and OA having a judge, and the estimate that our department put together was $36 million, because a lot of that would be done on overtime because we don't have the staffing to do it on regular time. But whether that's realistic or not, we don't know, because like I said, we don't know if we're going to get 10 requests or if we're going to get 200,000 requests or if we're going to get 500,000 requests because people want everything deleted now, even though that's not what the charge is.
Right. Okay.
All right. Anybody from the audience have any questions?
Kurt has a question. Kurt, do you want to come on and ask? So unmute yourself and just speak up.
Hi, this is Kurt from Yavapai County. It was just a general question for Amber about the expunged cases or charges being put in a separate hidden database. What is the purpose of still maintaining those records if they're going to be hidden?
Just that that's what the law says to do.
Okay, thank you.
You're welcome.
Okay. I want to bounce back one question. Really, 10:40. Jerry, have you left yet? This will be to Jerry and Jennifer and Jared. What is clear and convincing evidence standard that's in statute?
I looked this up in the jury instructions this morning because I knew you were going to ask that question. Let me see. It's more than a preponderance and less than beyond a reasonable doubt. So it's the middle standard under our cases. Let me find it.
So more than 51, less than 95. Huh?
Hold on, I can give you the exact wording.
The U.S. Supreme Court, I think, defines it as substantially more likely to be true than untrue.
Substantially more likely to be true.
This is the way the jury instruction reads: clear and convincing evidence. A party having the burden of proof by clear and convincing evidence must persuade you by the evidence that the claim or a fact is highly probable. This standard is higher than the standard for proof by a preponderance of the evidence, but is lower than the standard for proof beyond a reasonable doubt.
Okay.
All right, do we have any more questions out there?
Norma Chavez. Norma, sing out. Unmute yourself and ask your question. If you haven't had problems, hit your microphone, Norma. Okay, so I'll ask a question for you. Norma asked, will this only prohibit from public records release? So I'm understanding that we will still be able to share with other law enforcement agencies, correct?
No. Nope.
Right.
That's why I'm getting it deleted out of my system, because it can't even be saved by law enforcement.
So the local law enforcement would get a notification from you, Amber, and that notification would they get it from the court directly saying you need to set aside these reports?
The statute requires the court to send a copy of the order to the arresting agency and the prosecuting agency and DPS.
So my question would be, okay, so you're expunging a particular charge or set of a narrative within a report that may have other stuff in it. How is that going to happen for a local law enforcement agency in the records management system?
I don't think there's anything in the law that states that they have to modify their record at all.
Right.
But it has to be segregated, right? It has to be separated out and segregated.
That specifically states DPS will separate and segregate. It doesn't say anything about law enforcement, if I'm remembering correct.
The way that statute reads is that the arresting agency shall clearly identify in their files and electronic records that the arrest and charge are expunged, and they won't make them available to the public. It doesn't require that they destroy anything or seal anything, but they do have to clearly indicate that they are expunged.
Okay, I see that as being somewhat problematic for local departments to go into an actual report and, say there's multiple charges for different things.
Right. Now,
which
we debated that at length here we're advising courts if they have a hard copy of a record, somebody comes in, wants to see it, some of the information on the record relates to an expunged charge, they should wait until they get until they get a request to inspect that kind of record and redact it then, that they not proactively redact everything sitting on the shelf if nobody's asking to see it. So it'd be on request, they will need to redact. And if it's an electronic record, we are developing automated solutions for that will expunge portions of records, but the entire case, the entire record may need to be withdrawn from public access if it's not practical to redact. The first thing that comes to mind is the electronic verbatim recording of a hearing. Those are almost impossible to redact. So I think the courts are likely going to be instructed to simply withhold those from public access because it can't be redacted, really.
Well, so who's going to send these instructions and scenarios to law enforcement?
Well, the statute says what it says about what they need to do. They'll have to work out internally the logistics of complying with the statute.
Okay, but again, I see this being interpreted by 300 different law enforcement agencies differently.
Unfortunately,
Well,
Tony,
that's not right. That's not for us to really
that's the way
solve.
it is.
You know,
Second.
if they were all using the same case management system, there might be a global approach, but I'm sure they don't.
Okay. Amber, you said something. I think you and Mark stepped on each other. Go ahead, Amber.
I said, unfortunately, this is the way the law is written. So that's the way we have to put it out there for everybody to interpret. We can't do anything about the way it was written.
Okay.
All right.
No, I understand that.
All right, so we're coming up on our 11 o'clock. We'll see if we have any more questions out there from the general body. Do you see anything, Tony? Shayla, anybody?
Yeah, I don't see anything else.
All right.
I do have a concern, though, that I want to present to Jared. We have a hard stop at 11?
Well, I mean, is it firearm related or is this just another policy type question as it relates?
Policy question. In terms of the statute asking that for telling someone that they can say that they weren't arrested for anything. I see that as being is really hurting someone, at least someone who's applying for a federal position, of making that statement has catastrophic results for actually telling them in statute that they can lie about their arrest.
I don't know if that has anything to do with the NICS component.
Well, you're stating it on the 4473. So that's one issue when they ask you about drugs in drug arrest and you say no because it's been expunged. It becomes an issue down the line. If you're going for federal employment and you say no, I was never arrested for marijuana use. That could
right.
result in a permanent disbarment.
Right. So your first question, rephrasing that, if a person filling out the federal form for a firearm and they're not totally honest with that, did they look at the impact of that action in requesting a firearm? That would be the question.
Correct.
So Jared, can you answer that question? Did you all consider that?
So I did not consider that other than just to say that there are a number of states who have expungement provisions like this for a number of crimes, not just marijuana, that allow you to that have the same sort of provision that allow you to say you've not been arrested for that. None of those necessarily apply to. I'll put it this way: it depends on what form you're filling out, right? And so, if you are filling out a federal form that doesn't recognize Arizona's expungement policy, then you're likely going to have to answer that question differently than you would if you're filling out an employment application or some other application for the state of Arizona or for an entity in the state of Arizona. It is not a perfect solution. I understand that, but it's sort of. I would say there are a lot of states that are with this very issue as expungement becomes more and more prevalent for past convictions.
Okay. All right. Anybody got any questions surrounding that? All right. So I guess the next phase, first of all, I'd like to thank the panel for being available and answering our questions that we had pertaining to this. You were very helpful and insightful as to basically how this is intended to work and what some of the pitfalls that we may need to look at as we go through this process. So once again, we really appreciate you all taking time to answer these questions today. Now we're going to move into the 11 o'clock area. So Jared, if you want to stay, you can. Same way for you, Jennifer and Amber. But now we just want to talk about things we have missed. And based on some of the stuff we talked about today as it relates to the NICS task force, what do you see that we should be doing differently now that the world around us is changing as it relates to, this is one of the NICS categories, which is marijuana, that we need to look at as far as issues, that things we need to maybe look at solving or exploring more to get a better understanding how it's going to impact people who should not have firearms getting firearms. So with that, I open it up to the body.
Well, I'm going to go back to one of the major things that we talked about. And I know the Supreme Court has said no major things until everything with AZ Point is resolved, but that's the registration of release orders that routinely prohibit defendants from possessing weapons. Some cities have worked out a thing where like they'll hold on to, the police department will hold on to release order for like 10 days. But these aren't registered anywhere, and even if somebody is prohibited possessor, it's being maybe sent from the court that held the detention hearing to the court that's handling the case, and the file can be somewhere in between, and there is no way to verify it. I think that's a huge hole. I mean, we're talking about people that were arrested, and particularly for domestic violence, where it's got the mandatory arrest, I think that needs to be pursued.
Well,
and I understand. I mean, that's a big project.
Well, Judge Finn, we concur with you on that. And so we put that project on pause, but we are looking at picking that project back up. We just wanted to give some space and time. It wasn't only with the AZ Point initiative rollout, it was also that basically we got hit with this pandemic. And so there's a lot of things that came in like a tsunami that that put that project or put that initiative at risk. So we're hoping to be able to pick that project back up and scale it down to where we can roll it out as a phase or voluntary component. Based on a new method that we have that we identified during the pandemic. So we hope that when we go back to the courts sometime probably next year, that they will still see this as a need, which everyone I speak to, everyone I've spoken with, have agreed with you that this is still a vital need, that we have a huge gap within this conditions of release space. So it's not that they don't agree that this is a huge gap. It's just right now, everybody's resources are pretty much stretched. So hopefully by next year, sometime or another, we can pick this project up, and we're a little bit ahead of the game due to the fact that we do have a methodology for doing this, which this project is totally different than AZ Point. AZ Point was a state mandated initiative that moved everybody all at once. This conditions of release project does not have to be that way. This can actually be phased in on a volunteer participatory basis. And what I think is most of the to participate and volunteer once they have enough space after going through this pandemic, to start looking at how we can do this in a unified way. At least that's what I'm going to keep myself believing. How about that? Anybody else? Anything else that, and remember, when Tony opened this up, we're going to be looking at doing things a little bit different here for the NICS task force. We want to actually, I mean, we got a lot accomplished through the task force these last 10 years or so. But if there's things that we need to look at or issues we need to look at, please let us know. Anybody else got any thoughts?
Diane, Patrick, we got your issue on warrants, and that will be in the July meeting. And the voluntary committal of mental health, Diane Van Horn brought that up.
Loophole in mental health, voluntary commitments doesn't prohibit even temporarily LE when the Title 36 flips to voluntary. I must admit, I'm not an expert in the titles as it relates to when you're voluntarily committed and if that should be a prohibiting factor or not. I'm quite sure that would be something that's more so of a policy and legislative thing that would have to be looked at to make sure that we can show that there is an issue with those type of commitments. I mean, but
yeah, it's not in statute, not in federal statute. It has to be an involuntary commitment based on adjudication. There are some states that do institute through a state law that a voluntary commitment is a prohibiting factor within the state. You know, especially in light of recent events in the past week or so, you know, I have not seen that in any federal legislation that's pending in terms of the voluntary commitment. There are the red flag laws or the, you know, emergency and temporary orders that is out there. It may or may not get momentum. And if the state law, if federal legislation, you know, if it gets in federal legislation, that will drive what we have to do here in Arizona. But right now, Molly could correct me if she was still on, but I just don't see that you could get traction on a voluntary commitment in this environment in Arizona.
Amber stated that she had a DV victim relationship added to the new ACCH. That's great.
Amber, explain that to us. That's a good one.
So Biometrics is getting new live scans because they're getting a new system coming up. And so in their new system, they're programming all live scans statewide to have the officer, if he's selected domestic violence, to indicate the relationship of the victim. And we are putting tables in there that meet the state and federal standards of what the victims are. And when they click on that, It will then populate CCH so that NICS will know who the victim was, whether it's a spouse or ex-girlfriend or somebody who lives with them, not blood relative situation. We're hoping that that'll help NICS and help the agencies not have to provide police reports for that question.
Yeah, that'll really help NICS, especially when dealing with other states that don't have the same relationship standards. I know we still have an issue with misdemeanor domestic violence in that NICS still has to kind of root around and determine what's prohibited because of our statute. I know we brought NICS in to talk about that. That's still one of the outstanding issues that we've kind of not gone back and touched on.
Well, I think if Amber's adding this to the ACCH, that may clear up a lot of those.
Yeah, well, I think it was the actual act, not the relationship, that's in the misdemeanor domestic violence that can be interpreted. They have to look at the narrative of the report in order to determine if it's a prohibiting factor.
Well, if it's an assault, for example, because typically Arizona states it as that it's an assault, and then it has a designation as a D, I believe. But if she's adding tables on the live scan, the law enforcement can provide more information to that arrest. So if it's an assault, you know you have the threat or use of force, and then you now know the relationship. You can make that determination based on that.
That's great.
It's not so much. It's in part the 13-1203 A1, A2, A3, but it's also the disorderly conduct of 13-2904, because is that the threatened use of force? And so it's two things. What Amber's doing is going to help with relationships, because let's say Lautenberg only covers 3 relationships.
Right.
But in terms of the act itself, the most problematic statutes have been assault and disorderly conduct. And I'm willing to help work on any of this.
Perfect.
All
So
right.
my system did
That's good work.
is an action in there currently. We just need to start receiving it when we get the new live scans. If I get police reports, have it today, I can modify it today and have it be visible to the FBI.
That's good work, Amber. Really good work.
Kay entered in the chat section on the protective order petition, and in AZ point, we've broken down the live together now or in the past relationship into two live together as an intimate partner and live together but not as an intimate partner. Brady will not apply if the parties live together but not as an intimate partner, like roommates.
Correct. So the list we have goes into that type of detail. Like I said, it covers what our law states as a domestic violence partner or relationship, and it goes into what the FBI says is a domestic violence relationship. So it will say,
may help tremendously.
Yeah, so it'll say spouse, previous spouse, child in common, grandmother of suspect, adopted child, those types of things. It gets pretty detailed. I want to say there's 15 or 20 options on there. And then it says, I believe there's roommate non-sexual relationship, something like that in there. So it does go into those types of situations.
And then Kay just said that there are other Brady factors, but one is that the parties must be intimate partners as defined by federal law. And Kay said, thanks, Amber.
But answer this question, and Kay, you can respond in the chat if you want. But roommates is still a prohibitor, a state prohibitor, correct? Non-romantic roommate is still a state prohibitor, correct?
That's correct, because it's our state statute.
Okay.
Just like brothers, sisters, mothers, but they don't qualify under Brady unless they're an intimate relationship.
Kay said yes if the judge invokes ARS 3602G4.
Thank you, Kay.
All right. Anybody else have any thoughts about the direction of the task force moving forward? I want the next time we come in to see each other face to face that we have a new way or new projects that we're working on and making this thing even better going into the future. All righty. Our next meeting will be scheduled sometime in July. I was kind of hoping it may be in person. It depends on if we have the law enforcement summit or not. But that's the plan. If not, we'll hold one virtually, and we'll proceed as we have done today. So we're coming to the end of the meeting. So if you have any questions and wish to address the NICS task force, I told you all before you could have sent an email to CJ admin. I have not received any emails from the public or from the YouTube stream of anyone wishing to address the task force. So with that, I declare no one is typing. I'm gonna give it a couple of minutes. Oh, not a couple of minutes. I'll give it a minute to see if anybody's out there on the YouTube world that have any questions. Let's see if I get any emails. All right, seeing no one has sent me an email with any questions, I declare the April 20th, 2021 NICS Task Force meeting adjourned. Thank you all for attending. I really appreciate it. I hope this was better than the April meeting. Hopefully y'all were able to communicate if you chose to. Until next time, have a good rest of your day. Thanks. Bye.